Is of this my lord, the parties are all absent.
Appearance.
May it please my lord.
Yes.
My lord.
Sit down, sir.
Yes.
With me, my lord, V.E. Williams.
B.B. Williams.
Yes, my lord.
Appearing for who?
PC Enama.
PC
Enama.
Enama.
Enama spelled, my lord, E-N-A-M-A. Enama.
Yes.
And K-O-Tiku. Our appearance is for the defendants.
Yes. Any other appearance?
My lord,
any other appearance? Yes.
Atum Ebe Atum has been the lawyer for the claimant.
Yes.
He is not with us, my lord.
I'm seeing counsel online. Okay, it's Tiku.
Yes, my lord. Yes, my lord, it's Tiku.
This matter is for judgment. The judgment is ready. This is the judgment of the court. The claimants commenced this action on the 16th day of June 2016 via originating summons. However, on the 9th day of March 2017, the court ordered conversion of the originating summons to a general form of complaint. The claimant on 30th day of March 2017 filed a general form of complaint accompanied by a statement of facts, witness statement on oath, list of witnesses, list of documents to be relied on at the trial, and photocopies of documents to be tendered as exhibit. On the 24th day of May 2022, after the closure of the case for the defendants, the matter was adjourned to 18th day of October 2022 for adoption of final written addresses. On the 20th day of July 2022, the counsel for the claimants filed final written address of the claimants, while the counsel for the defendant files the defendant final written address dated the 5th day of October 2022, which was filed on the same date. The claimants on the 26th day of October 2022 filed motion on notice dated 25th day of October 2022, seeking for leave to amend the general form of complaint commencing this action. On the 15th day of December 2022, this court granted the application for amendment and deemed the general form of complaint and the statement of facts with its accompanying process already filed on the 26th day of October 2022 as properly filed and served. By the amended general form of complaint and the statement of facts with its accompanying processes, the claimant sought for reliefs against the defendant as follows. A declaration that Dominic Okpeche and Bison Odu are not the legitimate commandant and deputy commandant, respectively, of the Peace Corps of Nigeria, Cross River State Command. B, a declaration that Patrick Kate Odi and Patriot James Ochichi are the state commandant and deputy commandant of Peace Corps of Nigeria, and only them have the right and power to act as such in their various capacities in which they are entitled to. C, an order prohibiting Dominic Okweche and Bishop Odu from acting, operating, or parading themselves as commandant and deputy commandant of the Peace Corps of Nigeria, Cross River State Command, or doing anything that will complete with the rights and duties of the claimants. D, an order directing the third defendant to refrain from dealing with the first and second defendants, whether directly or indirectly, instead of claimants who are the legitimate leaders of the third defendant. E, an order of perpetual injunction restraining the first and second defendants from operating as state commandant and deputy commandant of the corps in Cross River State or parading themselves as such while the claimant are still the leaders of the corps in Cross River State Command. F, an order of perpetual injunction restraining the third defendant from dealing with the first and third defendant as if they are leaders of the corps in Cross River State while the claimants are still the leaders of corps in Cross River State Command. G, general damages in the sum of 50 million naira only for interfering with the rights and functions that are only meant to be exercised by the claimants. Embarrassment, intimidation, harassment meted to the claimant by the defendants. Following the amendment of the originating process granted to the claimant, the third defendant on the 22nd day of December 2022 filed amended statement of defense. On the 1st of November 2021, the second claimant testified as CW1 in proof of the case for the claimants. CW1 in the course of trial tendered documents which were admitted as Exhibit 1 to 14. In the course of cross-examination of CW1, 4 documents were tendered in evidence through this witness, and they were admitted in evidence and marked as Exhibit 15B, 16A, 16B, and 16C. At the end of evidence in chief, CW1 was cross-examined by the counsel for the defendant, and thereafter he was discharged. I have reproduced what transpired in the course of the cross-examination. I will skip reading it. The case for the claimant, I have also reproduced the parts forming the nucleus of the case for the claimant. I shall skip reading it. Counsel will read when they collect the hard copy of the judgment. Then the case for the defendants, third defendant, I have also captured the facts and evidence the third defendant relies in proof of his case. I shall also skip reading them. In order to save time, I shall go straight to the decision of the court. I have considered the processes filed in this suit, the evidence laid by the parties, the written submissions of counsel, and the oral adumberation before the court. The claimant seems their case on the claim that the first and second claimants were appointed as Cross River State Commandant and Deputy Commandant of the Peace Corps of Nigeria on the 28th day of February 2020. On the 28th day of February 2006 and the first day of March 2007, respectively. The first claimant has been, according to the claimants, the first claimant has been performing her duties and has also been instructing the second defendant to deputize for her. When the first and second defendant surreptitiously get back to the Peace Corps of Nigeria and started scheming to edge out the claimants. The claimants further about that the claimants were recognized by both government of Cross River State and the Cross River State House of Assembly, who gave them letters of recommendation. It is the case of the claimant that the first and second defendant started interfering with the discharge of duties of the claimants to the knowledge of the third defendant. But the third defendant took no step to stop the first and second defendant, which made the claimant to file the instant suit for the reliefs they are seeking. In defense of the case, the third defendant filed amended statement of defense on 22nd day of December 2022, wherein it denied all the allegation of facts contained in the claimant's statement of fact. The third defendant further about that these claimants are neither members of state commandant or deputy state commandant of the third defendant in either in Cross River State or in any state of the Federation. The third defendant is a non-governmental charitable use organization registered under Part C of the Companies and Allied Matters Act, and it has the power to redeploy and dismiss any officer of the third defendant. In the exercise, it is in the exercise of the powers conferred on the national commandant of the third defendant that the appointment of the first, the appointment of the second claimant, that the first claimant left the services of the third defendant by abandoning her duty post and went and took up appointment as press secretary to the chairman Etung Local Government Council of Cross River State, while the second claimant was dismissed from the third defendant in 2007 for usurping the powers of Cross River State Commandant Peace Corps through impersonation. As a result of the impersonation, the second claimant was charged before the Chief Magistrate Court. He was convicted and sentenced to 2 years imprisonment. However, in the meantime, he has appealed against his conviction to the High Court, and by the motion filed, he secured a bail pending the determination of the appeal. These are the summary of the facts that led to the filing of this case. In considering the merit of this suit, I shall start with the objection of the third defendant to the claimant's suit, suing an artificial person to the effect that on the issue of suing an artificial person in representative capacity, I quite agree with the counsel for the defendant that the claimants do not have the bias to sue on behalf of the third defendant, who is a legal entity, a representative capacity, when there is no such instruction to them to do so. In the circumstances, and in keeping with the extant provisions of the law, I treat suing a representative capacity as suing in personal capacity. Therefore, this case will be treated as being a case instituted by the claimants in their personal capacity and not a representative capacity. Considering the pleadings before the court and the evidence laid by the parties, it is apt at this point to consider if there is a valid employment relationship between the parties, to confer on this court jurisdiction to hear and entertain this suit. This court at this stage will deal with the issue considering the decision of the Supreme Court in the case of Owena, in the case of owners of MT Marigold versus Nigeria National Petroleum Corporation, reported in 2022, LPLR 568558 SC, which is to the effect that the requirements of giving parties the opportunity to address the court on an issue raised by the court suo motu is a general rule, which, like all other legal rules, has exception. For the exception, see the case of Epium versus Cross River State Independent Electoral Commission, reported in 2010, 14 Nigerian Kilolo Report Part 1213, page 106. See also the case of Tukur versus Government of Gongola State, reported in 1989, for Nigerian Kilolo Report Part 117, page 517. See also the case of Bola Omoni versus Jacob Adeboyega Alavi. In these cases, the Supreme Court held that principle that whenever court raises issues suo motu, parties should be given opportunity to address it, applies only to issues of facts and not issues of laws, as issues of law are treated as special circumstances. An issue of law or jurisdiction may be raised suo motu, and without hearing the parties, the court can decide the issue so raised. In the circumstances, I shall deal with issue of whether the claim of the claimant is an employment issue within the contemplation of the provisions of Section 254C of the Constitution of the Federal Republic of Nigeria 1999, as amended, to confer jurisdiction on this honorable court to adjudicate on the claim. The case of the claimant is hinged on their appointment and posting as commandant and deputy commandant of Peace Corps in Cross River State by the third defendant. The question to be resolved is whether such appointment amount employment capable of establishing employer-employee or master-servant relationship to clothe this honorable court with the requisite jurisdiction to entertain this action as it is presently constituted. The third defendant is of the view that appointment of the claimant was voluntary services without any financial remuneration and lacking in terms of conditions governing the said appointment. The implication of the position taken by the third defendant is that there is no contract of employment between the claimants and the third defendant, as there is no remuneration payable to the claimants. The absence of employment relationships between the parties is established, if established, will definitely render this court incompetent, incapacitated, incompetent to entertain the claimant's suit as it lacks jurisdiction to do so. To be able to see if there is a valid contract of employment between the claimants and the third defendant, the claim and pleadings of the claimants will be the focal point of consideration. As well as the defense, since Since trial has been conducted, the claimants relied on exhibits 7A and 4A to show that they are appointees of the third defendant. They also relied on exhibit 1A, 2A, 3A, 4A, 5A, 6A, 7A, 8A, 9A, 11A, 12A, 13A, and 14A, and 15A, and 15 in proof to prove that they are employees of the third defendant and they have been performing their lawful duties. A careful perusal of this exhibit will show that they are either letters of solicitation and appeal or response to such solicitation. Traditionally, the central theme of labor, employment, and industrial law is that employment relationship is expressed in the contract of employment. This contract, sometimes referred to as contract of service, is usually between the employer or master and the employee, worker or servant. Essentially, in employment relationship, the employment relationship is the main vehicle through which workers gain access to rights and benefit associated with the employment in the area of labor and social security. It is the key point of reference for determining the nature and extent of employers' rights and obligations toward their workers. The category to which a particular contract intended to be formed falls may determine the nature of its formation. Basically, no particular form is required as a general rule. In the absence of any statutory prescription, formation of a contract of employment could be formal or informal depending on the choice of parties. In other words, the contract of employment is ordinarily created whenever an employee is taken into employment by agreement of the parties. No special formality is required. The contract could be in writing or it could be orally made, a combination of written and oral agreement, and may even be inferred or implied from the conduct of the parties. To determine whether a contract of employment has been formed, that is, it has come into existence, it is necessary to establish that there have been a genuine agreement between the parties. This has to be agreement which the law will appreciate and enforce. In essence, whatever form contract takes, since governed ostensibly by the same rule of contract, it is governed by the same rules of contract. It must satisfy all the essential elements of a valid contract as regard to formation. See Section 91 and Section 54 of the National Industrial Code. What is clear is that contract of employment is consummated like every other contract, as it is subject to general rule of contract in the first place. Such contract, however, may be subject to statute, common law, or both. That is, common law reinforced or supplemented by statute. The precise law to which a contract of employment is subject may determine its formation. Thus, the subject of statutory prescription, the parties may now agree to any form of contract of employment containing any terms they desire, so long as the agreement does not involve an illegal purpose and not contrary to public policy. The freedom as to formation could be circumscribed and affected by the nature of contract that the parties can negotiate and actually enter into. The negotiation, which must necessarily involve the twin concept of offer and acceptance, must relate to terms that conform to accepted norms and the law, as well as to fit into recognized categories. The nature of contract of employment as between employer and employee has been known to belong to different categories. There is the office held at the pleasure. This has lost its meaning in present-day Nigeria, particularly since the 1963 Constitution reinforced by 1979 Constitution. Office at pleasure is now merely a feature of servant of the crown in England and not in Nigeria. There is another category which is subject to statutory regulation or conditions. There is a third category where the contract is for a definite period and backed by the Constitution. That is tenure employment. Finally, there is the ordinary master and servant relationship. See the case of University of Nigeria Teaching Hospital Management Board versus Inoli. See also Paponle versus University Teaching Hospital Benin. See also Board Management Federal Medical Center Makodi, and another versus Abakume, and the case of Olarewandi versus AfriBank. Applying the above principles of law to the facts of this case and Exhibit 7A and 4A, it will be right to state that claimants have failed in their duties to prove that they have a valid contract of employment with the third defendant, which the court should give effect to. The law is right. Employment relationship letter is the bedrock upon which the relationship between the employer and the employee is established, as the said letter will state the terms and conditions of the relationship, which will be the document to be considered by the court in determining the rights and obligations of the parties. Exhibit 15B, which is the constitution of the third defendant, the purported employer of the claimant, was tendered in evidence through CW1. It clearly reveals that the position of the claimant was not a position that are based on employment. The positions of the commandant and deputy commandants are part of those posts and offices that are not filled on employment basis. In other words, the position or office of the claimants are not offices to which the appointee are employees of the third defendant. These positions are filled by volunteers who do not have employment relationship with the third defendant, and they are not being paid remunerations. They are not being paid or are not entitled to be paid any remuneration by the third defendant. See Schedule 1 of Exhibit 15B. Furthermore, the offices or position to which holders are employee of the third defendants have been stated in Article 11 and 12 of Exhibit 15V, and the claimants do not fall within the category of these employees of the third defendant. Furthermore, considering the case of Shena Security Services Limited versus AfroPac, where the Supreme Court has stated the conditions in which, if existed, a contract of employment can be designed, have not been met in the case of the claimants in this case. In the circumstances, I have no hesitation in coming to the conclusion that the claimants in this case are not employee in the proper sense of the word, are not employees of the claimant in the proper sense of the word employee. Having regard to the provisions of Section 254C of the Constitution as amended, and the finding that there is no employment relationship between the claimants and the defendant, this court is bereft of requisite jurisdiction to hear and determine this case. As the dispute that was submitted before the court was not employment dispute, and it was also not a trade dispute between parties as contemplated by the provisions of Trade Dispute Act. In the circumstances and in the absence of jurisdiction, I have no hesitation in coming to the conclusion that this court lacks jurisdiction to entertain this matter, and therefore this case is struck out for lack of jurisdiction. However, this court being a court of first instance, I shall proceed to consider the claim of the claimants to see whether the claimants have proved entitlement to any of the reliefs being sought. The law is right that claim before the court is circumscribed by the reliefs being sought, and the claimant's duty is to adduce such evidence that is sufficient to prove his claim before the court. And the duty of the defendant is also to adduce sufficient evidence to prove his defense. See the case of Gabriel Atibi versus Kabel Metal Limited. In line with this Apex Court decision, I shall consider the reliefs being sought by the claimants before the court. The claimants have a total number of 8 reliefs. 2 of the reliefs, which are the mere reliefs, are for declarations, while the remaining 6 reliefs are ancillary reliefs dependent on grant of the 2 declarations. It is settled beyond peradventure that for a declaratory relief to succeed, the claimant must rely on the strength of his case and not on the weakness of the defense or even admission. The burden of proof on the claimant of establishing declaratory relief to the satisfaction of the court is a heavy one, in the sense that such declaratory reliefs are not granted even on admission of the defendant, where the claimant fails to establish his entitlement to the declaration by his own evidence. He has failed in his duty of proof. In other words, a declaration of right as sought by the claimant against the defendant cannot be made on admission or in default of pleading by the first and second defendant or the third defendant, or the reliance on non-competency of the third defendant witness to give evidence before the court. For whatever it is, the claimants have onerous duty to satisfy in the court that they are entitled to the exercise of its discretionary power to grant them declaration. However, this must be done based on cogent and compelling evidence adduced before the court. See the case of Dumes Nigeria Limited versus Nwakoba. See also Bello versus Iweka. See also Mutuashe versus Shorube and Kodinlie versus Odu. See also Adele versus Webade, where a plaintiff is claiming a declaratory relief at the trial court. At the trial, the court must be satisfied that he is entitled to such a declaration before such declaration can be granted. Otherwise, the failure to satisfy the court will lead to the dismissal of the claimant's case. The claimant, in attempt to prove the declaration being sought, tendered Exhibit 1A and 14 and Exhibit 1A to 15. These exhibits are not enough to convince the court of their entitlement to the declaration, in that the evidence to the effect that the first claimant abandoned her duty post and absconded from duty. This assertion was also supported by the abandonment in the third defendant's pleadings to the effect that the first claimant has taken appointment as press secretary to the chairman of Etung Local Government Council in Cross River State. For the second claimant, there is evidence before the court establishing that the third defendant has dispensed with his service. See Exhibit DWF. Furthermore, Exhibit 16A, 16B, and 16C establish that the second claimant was charged before the Chief Magistrate Court on charges of impersonation, and he was convicted and sentenced to 2 years imprisonment, though he is now released on bail pending appeal. With this damning evidence, the claimants have willfully failed to prove entitlement to the declarations being sought by extension, the remaining ancillary reliefs which are defendant on the grant of the declaration. For the second claimant, with the evidence before the court,
my dear, how do you raise the volume?
With the evidence before the court, which shows that the second claimant was actually dismissed from service, he cannot, as a servant of the third defendant, refuse to accept such acceptance, whether the dismissal was proper or wrongful. The second claimant has no choice under the law to reject or refuse to accept such acceptance. The only option open to second claimant, if he is aggrieved with the decisions of the third defendant to dismiss him from service, is to institute an action or to pray for the court to declare such action of the third defendant wrongful and claim damages for such wrongful act. However, throughout the 8 reliefs before the court, there was no reliefs on which the second claimant challenged his dismissal from service, and there was no reliefs in which the claimant sought for damages based on wrongful dismissal from service. On the whole, the claimants have willfully failed to prove entitlement to any of the reliefs sought before the court. Since I have already found that this court lacks jurisdiction to entertain this suit, the appropriate order to make is that order of striking out of the suit for lack of jurisdiction. I therefore struck out this suit for lack of jurisdiction. I make no order as to cost. Judgment is entered accordingly.
As the court please.
Thank you, my lord. We appreciate it.
Yes, Registrar, any other?
No, my lord, that's all, my lord.
Okay, Council, thank you very much.
Thank
We
you,
have
my
come
lord.
to
Thank
the
you,
end
my
of
lord.
today's proceeding.
Thank you, my lord.
The administrator, you can discontinue with the sitting.